All right, let's get going. This is House Bill 571 on Speaker Ralston's bill. Recall that we had one or two extended meetings on this prior to the recess. We've made a couple of changes in the bill. Let me ask Ms. Westmoreland and Mr. Drolet, if he's here, there he is, to come forward just in case there are some questions. I'm going to point out just a couple of changes that were made. We made some changes as per the request of the Sheriff's Association. Are they here? They were here. They're outside. They can speak for themselves, but my understanding is that they're satisfied at this point. With the changes that we made, there may be some issues going forward to work on in the other body, and that's fine. They're more technical than anything. In response to a concern that was raised by Representative Levitas, which I agree with, in the misdemeanor offender section in Section 3, what we did is we changed the law to assure that offenders were treated the same regardless of the date of conviction. That arose out of litigation that had been pending, but it was dismissed as a result of this legislation that's pending. But Representative Levitas brought up a good point, that we had a situation where somebody might have been, convicted of a felony, but then punished as if it were a misdemeanor, and then would not have sex offender registry requirements, and that doesn't make sense. So if you're convicted of a felony in that context, you need to be treated as if, regardless of what your sentence was, if the conviction is under an offense that you would otherwise have to go on the registry, you should go on the registry. We don't make the delineation between conviction of an offense and punishment of an offense. If you're convicted of a particular offense that warrants you go on the registry, then you should go on the registry and not have it related to punishment. It should be related to conviction. There was a case that came out literally last week on March 3rd in the U.S. District Court that struck down the requirements of providing email addresses, usernames, and passwords as part of the required registration information, and entered an injunction prohibiting enforcement of that provision. And so the substitute that you have in front of you reflects that federal court decision. The other change that was made has to do, and really the bulk of it has not changed since the last time we met on this, having to do the removal provisions in Section 11. And I'm going to go ahead and do my best to describe it, and I'll look at Ms. Westmoreland and invite her to jump in case I'm not, or Mr. Drolet in case I'm not stating it properly. But you have a summary in front of you, and it lays out all of the particular requirements for petitioning to come off the sex offender registry. And you have a summary in front of you, and I'd go ahead and invite you to look at that summary. It's very user-friendly, and I thank the AG's office again for their help in making this as user-friendly an exercise as possible. For those who can file a petition in paragraph A in Section 11, again, this is lines 473 to 531. That would extend to someone in hospice, nursing home, etc., and has completed the sentence for which they're required to register, or someone convicted of a Romeo and Juliet type offense after July 1st, 2006. And they meet the criteria of 1710 6.2c, which is existing law. You see the laundry list there: no prior conviction, no deadly weapon. The court finds no evidence of relevant similar transaction. Victim did not suffer any intentional physical harm. Offense did not include transportation of the victim, and the victim was not physically restrained during the offense. Or, in number 3, you have a situation where an individual is convicted of kidnapping or false imprisonment, but there was no sexual component to the crime. And then 4, the possibility they've completed the sentence for which they're required to register, and they meet the criteria of 1710 6.2c, which I just went over, which is basically A through F. On 3, you've got people convicted of kidnapping and false imprisonment with no sexual offense. Those people are now required to be on the registry. The question is, should they be? In this entire context, there's nothing in this bill, nothing, and I want to make sure that's perfectly clear, and the Speaker wants to make sure that the committee is perfectly clear on the fact there's nothing that takes anyone and removes them from the requirements of the registry. What it simply does is afford the possibility of certain individuals who are in a very narrow group, to be able to petition the Superior Court in order to come off the registry. The Superior Court judge may say, yes, you warrant coming off the registry. They may say, no, you don't warrant coming off the registry. Or they may say, not sure, come back in a couple of years. It leaves that discretion to the judge, which I believe and the Speaker believes is where the discretion properly lies. If an individual who meets certain criteria, again, your level 1 offender has not been leveled by the Sex Offender Review Board, it affords the ability for that individual, again, under a very, very narrow circumstance, to come into court, to come into Superior Court, and to petition the judge, again, to come off the sex offender registry. Again, this is judicial discretion. I want to make that, I'll say that about 1,000 times to be annoyingly clear, but I think it's very important. Individuals within a very, very narrow constituency of these offenders can come into court and petition the court to come off the registry. If they've not been leveled yet, if they've not been evaluated by the Sex Offender Review Board, SORB, the judge can go ahead and order such an evaluation. The judge orders the evaluation comes back, the judge takes a look at it and says yes, no, come back in a year, come back in 2 years, whatever the ruling is. And again, it gives that responsibility and that discretion to the court where it properly lies. And in terms of changes from the last time, that's basically where we were. There's nothing earth-shattering or there were no big changes in terms of Section 11, but that does represent a policy change from where we were before. It's a narrow policy change, but it's a policy change nonetheless, and I want to make sure that members were clear on it. Again, I had the opportunity after our meeting here a couple weeks ago to make these changes and discuss it with the Speaker. He's comfortable in moving forward with this. No doubt this bill should have passed the committee, and I do ask for your favorable consideration today, and the Speaker does as well. Should this bill come out and then go to the floor and pass, which I expect that it would, no doubt there'll be changes over on the other side. Again, I know the sheriffs have got a couple of technical concerns that they would just as soon address over on the other side of the Capitol, and we'll address that then. We'll try to answer any questions members may have. Mr. Levitas.
Thank you, Mr. Chairman. And this is really just I think a more technical question. Looking at line 527 on page 15 in section 11, the first part of the order, the first part, lines 524 to 527, talk about the court being able to release the offender. And my question, because as Mary Beth knows a lot better than I do, sometimes the courts construe the may to mean shall. And my question is on the sentence that begins on 527 ends on 528, where it says the court may release an individual from such requirements or restrictions for a specified period of time. One of the ways I think a court could read that is that the first part of F gives them the authority to release it, and the second says that essentially they can only release them for a specified period of time. In other words, they have the authority to release them, and they may do it, but for a specified period of time as opposed to a total and permanent release. And I didn't know if there's any wordsmithing, if you're comfortable that this will be viewed as alternative and permissive, that they can either do it in whole or in part.
Just speaking for myself, and I'll ask Ms. Westmoreland to weigh in as well if she wants. I think the last part of what you just said answers the question. I think it does convey the permissiveness of it, and the may. It gives the court, and the real crux of that section was to give the court the discretion to make a ruling regarding the specific requirements under the statute in whole or in part. And I think the may conveys the permissiveness that reflects the intent of the substitute. And again, and that's fine if that's your opinion. My only question would be whether we would want to include something that says, that makes it more clear that they may release them in whole or for a specified period of time. But again, if you're comfortable with it, that's fine.
I am. If you look on line 525, it's got the in whole or in part, and I think when you read the two together,
okay.
I'm okay.
Thank you.
Mr. Franklin.
Thank you. And it also in section 11, we're saying that someone may petition for release from registration if their offense did not involve a sexual offense. If their offense did not involve a sexual offense, why are they required to register in the first place?
Under the statute as it is as it's written right now, to my understanding, you can have an individual who's convicted of kidnapping or false imprisonment that would involve a minor, that requires them to register for purposes of the sex offender registry.
Right, and does this
even though there was potentially no sexual component to the crime.
Exactly. So, is there anything in this substitute that removes that requirement of registration for someone who does not commit a sexual offense?
It doesn't remove it. It does not remove it. However, once they've completed their sentence, they would be able to petition the Superior Court, assuming no sexual component to their offense, to go ahead and petition to come off the registry requirements. You know, you may have there may be a.
Mr. Chairman,
yes, ma'am.
Just a correction.
Sure.
I don't think the completion of the sentence applies to the kidnapping and false imprisonment.
Oh, okay.
If you look at A3 589, it does. I mean, line 489. I'm sorry. Yeah, if you look down there where it's talking about if you're required to register solely because of the kidnapping or false imprisonment and there's no sexual offense, the requirement for completion of the sentence is not attached to that provision. So that allows people, you come out, you're told to register, you can go petition immediately and say there's no sexual offense here, I shouldn't be required to register.
Oh, okay. But as a practical matter, that would occur after incarceration. Right. It may not occur. The probationary period may still be pending at that point. But as a practical matter, it would happen after incarceration. That individual, if they were convicted of kidnapping or false imprisonment, but there's no sexual component, at that point after incarceration, they could petition the Superior Court judge to come off the list.
But there's nothing in the bill that keeps them from having to register in the first place. That code section survives even with the substitute.
That is my understanding.
Okay, and one other question on.
Ms. Travis had a point.
Right, and we're not changing that with this substitute. Right. And then my final question.
Let me just make sure that it's clear, though. Right now, the ability for that individual to petition the Superior Court does not exist, regardless of whether or not there is a sexual component to the underlying crime. And this bill would allow for that petitioning, and that's the extent of it.
Okay. And on Section 5, I'm looking at the top of page 7, where if the offender is homeless and the information is the sexual offender's new sleeping, whenever there's a change in sleeping location, the homeless individual has to register with the sheriff within 48 hours. It almost seems by definition, how does the person know whether, which location, whether it be under a park bench, under a bridge, from one day to the next?
And that change was made at the request of the sheriff before, if I recall it correctly, the notice had to be given prior to the sleeping, that individual determining their sleeping location. As a practical matter,
because that can change daily.
That can change daily.
So basically, we're requiring, if it changes
after
daily,
the fact.
Then within 48 hours of that day's change, they've got to report, and then 48 hours
That's
after
right.
tomorrow's change, they've got to report.
The difference being that it's an after-the-fact reporting as opposed to before-the-fact, if I'm stating that correctly, and I think I may be. Mr. Levitt, you know what? Ms. Abrams.
Just to clarify that.
Then we'll come back.
So they're being forced to report where they were, not where. Yeah. Can we talk about the policy implications of that? I mean,
It's really where they are, just to make sure that it's clear. What we had before was we're trying to mandate a reporting of where they are going to be. And as a practical matter, according to the sheriffs, and it makes sense, a lot of times they did not know where they were going to be. And so what we try to do is to make it slightly more practical in that once they've made that change, to go ahead and report it 48 hours after they've made that determination.
And I guess to Mr. Franklin's point, particularly in Metro Atlanta, you won't know if you can have a bed in a shelter until the night of. So as a practical matter, that may change from day to day because you may go between the Gateway Center and St. Luke's and then City of Refuge and then back to St. Luke's. you won't know. I guess I'm wondering about how does this operationally actually work?
Operationally, I mean, if those changes are made, then that reporting occurs again after the change is made as opposed to before. We have to have some sort of system where there is monitoring, or I think we have to have a system where there is monitoring. There is some sort of idea of where these individuals are.
That's exactly.
As a practical matter, knowing beforehand is much less of a possibility than knowing after. So we're trying to make it as practical as possible, understanding full well that it's difficult.
I guess my last question is, I mean, it's effectively what you're creating is a daily reporting requirement for anybody who lives in an area where they won't have any permanent sleeping arrangement. And
It depends on the amount of change. I mean, as a practical matter, and please correct me if I'm wrong, it depends on how often the change occurs.
I mean, I work with the homeless, and
Yeah.
as a practical matter, they change locations on basically daily. And so under the terms of this, within 48 hours of change, because they will never know where they're going to be because of the restrictions in beds and essentially the fact that they don't have a permanent location, we're requiring. I'm just wondering if the solution is actually going to be more problematic than the existing problem.
I would submit to you that it's actually less problematic than the way it was written before. I don't sit here and tell you that it's perfect, not by a long shot. But as a practical matter, we have to have some sort of method of monitoring to the extent that we can. This affords the ability of the individual, if they're homeless, to report after the fact as opposed to before. I can't tell you that it's perfect, and if there is perfect language, I'd invite anyone to come forward. In the last 2 weeks, we haven't had any such input. We're trying to make it as workable as possible in a scenario which, by definition, is somewhat unworkable to begin with, admittedly.
Thank you.
Yes, ma'am. Mr. Knox.
Mr. Chairman, thank you. This may be a question for council.
Sure.
If we have and I'm trying to understand, I know what we're trying to do is try to identify some place where we can have some opportunity to locate someone who is a sexual offender, to be sure if they're still in the state, the county, or whatever jurisdiction. And this, I'm not sure whether this will do it or not, but do we apply the same protocol on, say, a sexual offender who owns a home in Atlanta and has a place on the beach and maybe one in Florida? Do they have to report each time they move between one of those residences to the other?
They do. If it's a residence address, you have to, if you look at the beginning of paragraph 5.
I'm talking about, for instance, if I go to my beach house for the weekend, do I have to report, even though I'm not homeless, do I still have to report that I moved, even though it was last Friday I was someplace else?
If you were summering in Florida and changing residence addresses, yes, you would. If you were just going away for a weekend, I don't think that this is applicable to a weekend.
Well, I'm trying to get if there isn't some issue here, because if I live under a bridge and I got to tell them I moved to a different bridge, but if I've got a house on the weekend and I go there for the weekend, I don't have to tell them that. What's the difference?
Well, that's probably a good point.
I'm not arguing with you. I'm just trying to understand.
Part of the issue here was the decision that was down that said that we couldn't say somebody couldn't be homeless as a residence address. And so we're trying to, you have to have, the desire is to have a policy to track everybody that's a sexual offender. And so if you have a residence address, that's one way to keep track of somebody. If you don't have a residence address, how are you going to keep track of them?
Well,
I hear your point,
yeah.
though, because if you're away every weekend, I don't believe under current law you have to reveal that you're going away for a weekend.
Would this be more practicable? First of all, I'm not sure that someone who lives under a bridge, which we know happens, that this would be a particular concern for them anyhow. The reporting requirements are not going to be terribly weighing on their mind. I don't think they're looking for the next place to be able to find out of this wind and rain and whatever, not whether or not they're going to get in trouble from somebody for not having reported where they were 48 hours ago. They probably can't even remember. But I'm just trying to get, would it make more sense as far as a law enforcement tool, which I think what we're trying to create here, that passes muster? Would it make more sense just to have a geographical area that they reside in? You know, because they tend to stay where the best bridges are, for one thing, or they tend to stay where the shelters are. Why wouldn't it be a neighborhood that would, you know, that we'd be looking at to be able to identify where their quote residence is, whatever that means?
I really can't answer that. I mean, maybe somebody from law enforcement would give you a better response.
Let me ask the sheriffs. I mean, as a practical matter, I realize that these are tough provisions in order to implement. We get that. As a practical matter, do you see the provisions that are in the bill right now as being more workable than where we were before?
I do, Mr. Chairman, and I think it actually helps those that are homeless to give them a little extra time to make that notification. One thing, though, they may sleep under a bridge or in a more than one location, and obviously the whole purpose behind the registration of offenders is to identify their location. It's unreasonable to think that they should be required to do anything beforehand because of that factor. They can't. I mean, in fact, if you look at Fulton County, I'm not sure that homeless folks downtown have a real easy ride in terms of registering with the sheriff's office anyway. If they're registering at the jail, I'm not even familiar. They may be registering downtown. But I think it's more workable. Our folks think it's more workable. If you wanted to give them a little more time to do that, I don't think we'd have a problem with that. But it is very difficult to keep up with these folks. Now, on the other issue about we want to see all locations in which folks that have multiple residences be required to notify the sheriff's office about those residences. We want to know where folks stay. A lot of folks will sleep at a residence, they've got an address, but yet they go spend time with their girlfriend, their boyfriend, and others. And we want to know all those locations. So that's not something, Mr. Knox, that we don't want, and we do want to seek out in this legislation. But I think you're helping the homeless folks here. I really do. I don't think you're hampering.
You know, on the multiple locations, I mean, we can certainly work on that issue going forward.
We haven't addressed that this though, have we?
No. Mr. Franklin.
I just I'm a little concerned that when we first went into this several years ago, I believe it was 95, 96 thereabout. In our zeal to be tough on child predators, which we all ought to have a zeal to be tough on child predators. I co-sponsored the bill with Representative Massey to provide for the death penalty for child molesters. And I don't think there's anyone in this body who is as passionate about punishing those who harm our children as I am. But it seems that what we have crafted and we're seeing is this is at least the third version of trying to fix, maybe it's the second version of trying to fix what we did then. That what we have apparently done is not really trust our system of when we punish someone, we give them a sentence, and when they have completed their sentence, we say, well, you're not really done yet, and there's more. Even though you've paid your debt, you really haven't paid your debt. Here's a life sentence for, and even as this bill doesn't fix, you did not commit a sexual offense, but we're requiring you to register nonetheless. And it seems like every time we try to fix something that a court has addressed, then we open up new cans of worms because we're not really addressing the underlying issue of if this person really is that dangerous, then why didn't we try them for a capital offense in the first place and be done with them? Or if they're not, if it's okay to be out on the street, then why are we still requiring these other things? I think that's a policy issue we need to look at.
Well, Mr. Franklin, I can only speak for myself. I wasn't a member of this committee during the first two or three laps around the track. But in the interim, what has occurred as a practical matter is that we have several court decisions, both at the federal and state level, which have addressed certain sections of the bill, of the law, that need to be changed from a cleanup standpoint. From a, when does the sentence end viewpoint that you expressed a minute ago, if you recall when we first, dove into this a few weeks ago, months ago, I think the point is not lost on anyone here from either side of the aisle that, punishment needs to fit a crime. And that, in the theft context, shoplifting is very different from armed robbery. And we have different punishments for that. And I think, in years past, there may have been a drive for, certain punishments of certain offenses, and perhaps without being very particular on that particular offense. What this bill does is attempt from a very practical, with the substitute attempts, what the Speaker's legislation attempts to do, is to bring a little more graduated consideration of what warrants being on the registry and what doesn't. And I'll say again, the substitute that you have here does not, in my opinion, I think in anyone's opinion, undermine the underlying tenets of the original intent of the bill. But what it does do is that it acknowledges that you do have some individuals in this realm who are a far greater risk, and you have some individuals in this realm that are far less of a risk. In terms of the kidnapping and false imprisonment standpoints, there may not be an underlying sexual a component to that particular crime, but there also may be situations where those individuals are involved in that particular crime and may have some other history that we don't know about, that the judge doesn't know about. And it provides the ability, we always want to err, and I think the gentleman agrees, we want to err on the side of caution. By the same token, we also want to err on the side of rationality. And what we're trying to do is to strike that balance between the two. Those individuals will have the ability to petition the Superior Court and nothing more. And if they're credible, my sense is that the judge will go ahead and act accordingly. And if they're not, then the judge will act accordingly as well. And that's, I think, from a policy standpoint, a significant change than where we were before. So it strikes that balance. The Speaker believes it strikes that balance. I believe it strikes that balance without undermining the underlying tenets of the original legislation, which was to protect our children, which is foremost. But the gentleman's point's well taken. I don't have the history that he does on this committee. What I'm trying to do is to take a very measured approach to this issue, erring on the side of caution, but also perhaps bringing in a bit more a bit more structured analysis of the different crimes and the punishments that are warranted from them. Mr. Levitas.
Thank you, Mr. Chairman. I think you've answered one of my questions, and I was going to ask why we're getting folks without having a sexual component to it. I have a question about lines 187 to 191, and it's really a venue question. This is the part of the bill that says that they have to register within 72 hours with the sheriff of the county where that offender sleeps upon release from prison. Where is venue, and it's leading me to another subpart of this question, where is venue if that person never registers anywhere? How do you establish where venue is? In other words, and this is one of the things I've actually discussed with the sheriffs, this is not their position, it's just something we've talked about. What about requiring the offender to register within the county where he or she is released so that they at least have venue in the case where somebody just refuses to register? Because otherwise I don't know where the registration, where venue would be.
And from a legal perspective, that's not an issue. From a practical perspective, I think you have the problem of folks are released from a prison and most don't stay with that. I mean, they're not going to stay in that county. They're gone that day. They've got their bus ticket or whatever, and they're gone. So if you're adding a component that they walk out of the door in Wilcox County, they have to go to the sheriff's office in Wilcox County before they can ever leave Wilcox County.
Or to the warden. I don't care where they register. I'm just saying so that you've got venue from the minute they step foot outside the jail.
Because and again, with probationers and parolees, you're supposed to have an address. With people who max out, they don't have to tell you where they're going to live
unless we tell them. Yes. But so my question goes back to will you have venue? Where is venue in a case where somebody just flat out they leave prison, they never register? Period. Where's venue?
It's a good question.
Okay,
And I
so
think it's going to end up being, if you find
Wherever they reside.
wherever they end up residing,
right,
that's where they fail to register.
but you can't issue a warrant for them until you've found where. Okay, so again, that's nothing to hold up the bill on. But when y'all get to the Senate side, I'd ask you to at least take a look at that. And then I may have asked you this at the last hearing, and if I did, I apologize. Lines 504 to 505. Why are we putting a 2-year ban? I mean, a year's a pretty long time, and I understand it will create additional paperwork. But if I am a rejected applicant, that's a long time to tell me I can't go back if I think I got a bum deal and make an application. Is that really just a judicial economy provision? Is that the reason for the 2-year ban?
Well, part of it, I mean, correct me if I'm wrong, there's something to be just considered that there is an appeal provision earlier on in the bill where now it's a discretionary appeal to the Court of Appeals. It's not an appeal as a matter of right. I want to make sure that's clear. So, pending a reapplicate or repetition or another petition, they could go ahead and file an appeal to the Court of Appeals in the interim. So.
But again, it would be discretionary. Again, this is nothing I want to hold up the bill on.
Sure,
but
no,
it's something
it's
I'd
a
like
fair
y'all
question.
to.
No.
I'd like y'all to at least have that discussion in the interim.
Ms. Westmoreland, did you want to go ahead and address that at all?
That was all I was going to say. Is you do have the time period for an appeal from the denial of the removal, and how long you determined to wait for reconsideration is.
Well, and actually,
policy.
now that I think about it, when you talk about that, by the time that hearing gets, you may be close to getting to that 2-year point anyway. So if you were able to do it every year, then you'd potentially have a petition filed overlapping with your last one. So you raise a good point. Final quick question, Mr. Chairman, if I can just ask last one.
Sure.
And this is something that Representative Abrams brought up last year and this year. And I guess even as someone who I think can fairly be described as relatively on the side of pro-prosecution, the failure to register in law, and I'm actually pleased we've removed this life provision. I thought that was a bit over the top, is a 10-year offense for the first time that you failed to register, which is essentially you haven't filed a piece of paper. Has there been any discussion about having a broader range rather than a minimum 10 years for failing to register? And is that, again, something that you might be willing to engage in if it gets over the Senate, or do you feel that this is the appropriate amount of time for failure? I know that's a policy question.
That's not our call.
Right, I know.
Ms. Westmoreland won't touch that with a 10-foot pole, I guarantee you. We've been dealing with each other for months
and that
now.
may be, I'm not anticipating Representative Abrams, but that may be something we discuss.
No, and let me just make sure it's clear. The change there arose out of one of the state Supreme Court decisions that we had. Recall the failure to register the second time brought a potential life sentence, if not a mandate, I don't recall. That was declared unconstitutional under the 8th Amendment. What we did was the first offense had a range of 10 to 30, and what we did is we maintained that for the second offense, 10 to 30. That, in my opinion, speaking only for myself, that is, along with one or two other states in the nation, the strongest law in the nation. And we maintain that posture with the second offense, but we don't go up to life, obviously, because or anything higher than 10 to 30, because that would potentially run us afoul of the courts as well. So it's a straight up or down policy question.
Right, and I must have misread it. I thought that was on the first offense. The first offense.
It is the first.
Okay,
The
because when
first
you
and the
said
second they mirror each other.
they mirror each other.
Yes,
So
sir.
the first offense is also 10. Right.
10 to 30.
Okay. Thank you.
Thank you, Mr. Everson.
Thank you, Mr. Chairman. One quick question. Line 272. Beginning with the word any sexual offender. Those individuals moving from state to state, I noticed that they are required to request of their sheriff's department to forward the information. What's the time frame for that? Say, for instance, someone is moving here from Pennsylvania. Do they fall under the same 72-hour rule? Or do they have 6 months to request that information? 4 months?
I think they
Is
would
it,
subject to
72?
72 hours.
Okay, thank you.
I mean, it's not spelled out here, but I think they would be.
Ms. Abrams. Okay. I see no further questions. Again, this, Mr. Sessler, did you have something? Okay. This is a work in progress. We'll, if the committee chooses to move this out today, we'll get it on the floor and move it out to the other side. But it is a work in progress. There will be some changes. I know that we do want to look at some practical considerations that the sheriffs have brought up, and we respect that 110%. It's the very definition of something, the translation between words on paper and how it gets implemented on the street, and we understand that. Mr. Sessler.
Mr. Chairman, I don't know what posture we're in.
I'm about to take a motion.
Okay. I will say to the point that Representative Levitas raised relative to the mandatory minimum 10 in Section 8. I guess philosophically, I tend to be a 1 to 30 kind of guy. Believing there ought to be a lot of range. If you've got a bad actor that needs to get a significant sentence, then I think courts ought to have that ability to do that. I'm wondering if there's a sex offense that someone gets sentenced to 1 year, 2 years, 4 years, 5 years, and failure to register because of the way the law is constructed gets them a 10-year sentence. Now, I understand there's got to be that there's some prosecutorial discretion whether this is brought, but to me, a mandatory minimum sentence of 10 years is what we might consider for the most serious crimes. I mean, the main measure itself as opposed to registration. Not to imply registration is not an important issue in itself. I just don't know. Again, that's why I asked what the posture of the committee is. I would be prepared to offer an amendment making that 1 to 30 versus 10 to 30.
On the first offense, or on. It doesn't distinguish between first and second.
It doesn't distinguish. Right. And I think if you've got a person that doesn't register, they're convicted of 2 years, they do the time, do some of the time, and they convict again, then the judge, I think the folks we put on the bench would certainly be encouraged to give something more in the 10 to 30 range for the second time. But I think, again, the sets of facts we can present.
What line are you on, Mr. Sessler?
I'm on line 258.
Okay.
Section 8. I would just, sensitive that the chair is the author of the bill, I just wanted to.
No, the speaker is the author of the bill, but the gentleman's point is well taken. I will say that that's why we have the amendment process.
Okay.
So if the gentleman wants to offer an amendment, he can. It's certainly today is no different than any other day.
Sure.
Amendments come, and if the votes are there, they pass.
Okay.
Just want to make sure that we're taking a measured approach on it, but I think the gentleman's point is well taken, and certainly won't get in the way of any proposed amendment.
And if it's the chair's desire to speak to this some more when the motion's made, I do intend to make that motion at the appropriate time. I just, from a policy standpoint, think that, again, we're talking about the offense of failure to register in essence. I think a 1 to 30 again provides some judicial discretion. I think those things that we typically have 10-year mandatory minimums are those things that if this offense is committed, these elements are met, then we believe it should never, ever, ever be less than 10. And there are some offenses for which that's the case, and I would support. I don't know that it should always be the case, in my opinion.
I would caution the gentleman that if you're going to address it in that way, you would probably want to take a certain approach on a first offense, and then on a second offense be a little more of a hammer. I will tell you that our law right now is the strictest in the nation. That does not mean that it's perfect, but I would encourage the gentleman and the committee to err on the side of caution when it comes to that, especially on a second offense. That's just my 2 cents worth on that. Mr. Collins.
Don't have
Oh, I'm sorry, Ms. Abrams.
At the appropriate time, I'd like to be recognized for a motion.
This would be that time. Thank you.
Move to pass HB 571, LC 294213S.
Second.
Motion of due pass by substitute by Representative Abrams of House Bill 571, LC 294213S, second by Representative Collins. Are there any amendments, Mr. Sessler?
I'm crafting one. I think I'm close to it.
And I think just for verbiage sake, we could, to the extent that we can get it exact, that's fine. If we wanted to go ahead and have an amendment, then we would go ahead and pass by substitute for Ms. Travis and then give her the discretion to word it as appropriate.
Mr. Chairman, I think the existing language that's in there that has been stricken on lines 259 and 260 really gives that to us almost. I will read this a couple times if I need to, Representative Abrams has helped me. If it pleases the chair, I'd like to read the proposed amendment.
Sure.
I'm reading on lines 258 through 260. Again, this deals with the failure to register. Picking up on line 258, shall be guilty of a felony and shall be punished by imprisonment for not less than one nor more than 30 years, provided, however, that upon the conviction of the second offense under the subsection, again, reading and maintaining the otherwise stricken language, the defendant shall be punished by imprisonment for not less than 5 nor more than 30 years.
Okay, read it one more time, just so we're all clear. That was fairly clear, but I just ask you to repeat just for clarity's sake.
258 shall be guilty of a felony and shall be punished by imprisonment for not less than 1 nor more than 30 years, semicolon, provided, however, that upon the conviction of the second offense under the subsection, the defendant shall be punished by imprisonment for not less than 5 nor more than 30 years. In essence, restoring that stricken language.
Okay.
And changing the numbers.
Is everyone clear on the amendment?
It's a 1 to 30 first offense, 5 to 30 second offense.
1 to 30 first offense, 5 to 30 second offense. Any discussion on the amendment? Seeing none, all in favor of the gentleman's amendment?
I'd like to speak.
Oh, I thought this was the.
No. I'd like
I thought
to
this
speak
was
to
the no,
amendment.
thank you.
We've had this discussion before, and I've made my views pretty clear on it last year. I think to characterize this as a paper offense, as if it's, I've heard people say that, as if it's tantamount to letting your driver's license expire, is absolutely wrong. This is part of the punishment that you receive for committing one of these offenses, in addition to the prison time that you've served, is an obligation to register. This is the absolute fundamental trigger for providing us an opportunity or an obligation to track these individuals. I think 10 years is appropriate. I think we absolutely have to have a strong deterrent that exists to make sure these individuals are complying with the obligation to register. If they're not registering, then the entire crux of what we're trying to do in terms of tracking these dangerous individuals is eviscerated. So I know we have the amendment process. And it is what it is, but I'm going to vote no, and I encourage my fellow committee members to do the same.
All right. In light of time, I'm going to have one response, Ms. Abrams, on that, then we'll go ahead and take a vote on the amendment. It's not to bypass any particular committee member. We've had a motion. We've had an argument against. We'll have a rebuttal for, I assume, and then we'll go to a vote. I'm just trying to be respectful of time in terms of our convening time. Ms. Abrams.
Thank you, Mr. Speaker. Sorry, Mr. Chairman. Whenever I'm talking about 571, I always...
No, we're just carrying his bill, that's all.
With all due respect to Mr. Ramsey, I do believe this bill and this amendment adequately captures his concerns. This registration applies not only to dangerous felons who are Category 3, but to people who would have been captured under Categories 1 and 2. And the Level 1 and 2 folks are the people who we are most concerned about, because they are captured by a fairly expansive law. And that expansive law has to recognize the expanse of our reach, both on the punishment side and the obligation side. And I think the obligation to register, while fundamental, captures people who would not believe themselves to be necessarily captured by this. So someone who could have been convicted 10 years ago of a crime that at this point would be considered a misdemeanor are still obligated to register until they are able to petition themselves off. My concern is that, just given the conversation we had today about how this is applied, how you comply with this law, raises the specter that we would unfortunately capture folks who are doing their best to meet their obligations, but for making a mistake could be sentenced to a minimum of 10 years in prison. And that, I believe, if we're talking about evisceration, that's an evisceration of, I think, more fundamental rights. I think we give the courts the ability to recognize and to punish as draconianly because I find that to be a bit strong, but we can punish as harshly as possible those dangerous predators who fail to register, and there is the ability to do that with this bill. But to set a minimum that doesn't recognize the lesser included offenses, I think would be inappropriate, and so I encourage everyone to vote in favor of this amendment.
Question occurs on the amendment by Representative Setzler on lines 258 through 60. All in favor of the gentleman's amendment, please raise your hand. Opposed? And the amendment is adopted. Are there any other further amendments? Seeing none, the question occurs on the motion by Representative Abrams of do pass by substitute, LC 294213S as in Sam. All in favor of the lady's motion, please signify by raising your hand. Opposed? And the motion is adopted. I thank you for your attention this morning. We will have a meeting tomorrow afternoon at 1:30. The agenda, I think, already went out, and please do your best to be there. Thank you very much.